Hello friends, I am Parveen. Welcome to my channel Stenographer, a white collar job. Be ready for the dictation. 5, 4, 3, 2, 1, start. Learned counsel for the respondent, on the other hand, contended that there is no apparent error in the judgment of the High Court in quashing the criminal proceedings on the ground of limitation. Stop. The High Court has correctly treated the handwritten notice sent by the appellant on 27th April 2020 as a valid notice in terms of Section 138 of the Act, as the appellant had given the notice in written within 15 days. Information stop being aggrieved by the judgment and order so passed by the learned single judge. The landowners are before us in these appeals. Stop. We have heard Sri Gil Singh and Sri Pavan Kumar, learned senior counsels, appearing appellants, and Sri Gil Singh, for the learned counsel for the state. Stop. The learned single judge in the impugned judgment and order has not awarded interest on the said amount. Stop. We are or the that in view of the Constitution bench decision of this court, the learned judge ought to have grants interest on the said amount in view of the above discussion, we allow these appeals, modify the order passed by the learned single judge and remit these appeals to the reference court to determine the compensation payable to the landowners in the light of the judgment and order passed by us in these appeals. Stop. We further direct the reference court to complete this exercise as early as possible, at any rate within higher limit of 6 months. Stop. Next para. The primary question for consideration in all these appeals is whether the respondents were entitled as of right to one more opportunity to switch over from the contributory provident fund scheme of which they were members to the pension scheme and the general provident fund scheme implemented by the appellant with effect from 28 November 1988. Stop. Broadly speaking, the contention of the respondents is that they were aware of the switch over option since they were posted in remote areas of Punjab, while the contention of the appellant is that a large number of opportunities extending over 8 years were given to the respondents to exercise the switch over option and that they could not claim any right to any further opportunity to make the switch over. Stop. Being aggrieved by the decision of the learned single judge, the board preferred writ appeals before the division bench of the High Court. Stop. By a judgment and